Assalamualaikum and hi to my respectful lecturers, Sir Syed Muhammad Najib, and to my fellow friends. My name is Qurratu BINTI BAHARIN, metric number is 1190813, and I from Camp E3. For this individual assignment, I have chosen 3 cases regarding business law. Among the titles that I chose were Gemencheh Granite Sdn Bhd versus Puncabahan Sdn Bhd and another. Second, Malayan Flour Mills Berhad versus Su Enchi, the administrator of the estate of the Su Chengchor, the disease, and another. And the third one is Hong Leong Finance Berhad versus Max Double Construction, Sdn Bhd, and others. In this video, I will only review one case in which is Gemencheh Granite Sdn Bhd versus Puncabahan Sdn Bhd and another. For information, this case was heard in the High Court Kuala Lumpur and judged by Hasna Muhammad Hashim on 18 September 2012. In this case reviewed, I will calmly explain 3 important things which include the fact of the cases, issues, and court decisions that have been decided. But first of all, we need to know the plaintiff for this case is referring to Gemencheh Granite Sdn Bhd, which is a company that operates a quarry and supplies construction materials such as premix, crusher-run, and tack coat, while the defendant is Puncabahan Sdn Bhd and another, which is the contractor and a customer of the plaintiff. So now, I will start the facts of the case for this case. The first defendant had ordered crusher-run, premix, and tack coat from the plaintiff with the total cost of material supply amounted to 982,923 ringgit and 88 cents for the construction and upgrading a stretch at Jalan Bahau, Jelai Dangi, Kuala Pilah, Negeri Sembilan. After that, when the order was completed, the plaintiff delivered the item to the defendant. Next, on the date of 27 May 2009, the defendant had already made a continuing credit as agreed with the plaintiff. Then, on 24 March 2010, the credit facilities implemented were reviewed. As a result, the credit limit was increased along with the certain condition and a signed open date check from the first defendant. After the construction and upgrading of the stretch were carried out, the plaintiff gave notice of payment for the materials that had been supplied. Unfortunately, the defendant refused to pay the outstanding payment of 512,557 ringgit and 81 cents and claimed back that the material supplied to them was defective materials and did not meet the specifications set by the Jabatan Kerja Raya, which is JKR, and the completed works were discovered to be defective. Thereafter, the first defendant cancelled the check for 500,000 which had been given to the plaintiff and conducted the test and analysis on the material supplied. Subsequently, through a letter dated 20 July 2010, the plaintiff had proposed to conduct a joint test on the materials and send it to accredited laboratory mutually agreed by the parties such as UTM, College University Technology Tun Hussein On, and IKRAM. Then, the first test on the material used was done at the College University Technology Tun Hussein On, and the test results found that the crusher-run premix complied with the JKR specification. However, at the same time, the test on the material was done also at the Geolab Sdn Bhd and found that different result, and this test was confirmed by the prosecution witnesses 1. So, to know the correct result, then they run further tests. Subsequently, Material samples were sent to ICRAM, and the plaintiff also sent the material to the Master Soil Laboratory for the double confirmation. The result of the ICRAM test showed that the quality of the crusher run did not follow the JKR specification. The plaintiff then informed that the defendant through letter dated 14 April 2011 and 19 July 2011 requesting further testing and samples were sent to College University Technology Tun Hussein On, UTM, UKM and Text Technology Sdn Bhd. This, however, was not done as the defendant had replaced 90% of the run crusher. Finally, the defendant has made a counter-claim to for the cost of buying and purchasing the crusher runs from a different supplier, as well as the cost and expenditure of the repairing the damaged road. The second part that I will explain is the issues that arise in this case. The issue is the defendant claimed back that the material supply was damaged and did not match with the specifications of the Jabatan Kerja Raya, which is JKR. So, in this case, it is necessary to see whether the material supply by the plaintiff is really defective or not. Also, since this is an application for the plaintiff for the damaged material, then the judges must take into account when the material was damaged, whether when it was sent and supplied to the defendant or not. The last part is I will explain about the court decisions that have been decided. The High Court Kuala Lumpur judges have reached 4 judgments accepting the plaintiff's claim with the causes and dismissing the defendant's counterclaim with the cause. For the first court decision is 2 tests were done based on the oral and documentary evidence prior to the first defendant's agreement to purchase the crusher runs. The first test performed on the submitted sample failed to meet the requirement. However, a second test was carried out and the samples that were tested satisfactorily meet the JKR standards. This was proven by the testimony of PW1, DW1, DW2, DW3 and DW4. The materials were then delivered to the project location. Next is the first defendant was considered to have accepted the crusher runs and all other materials supplied when they were delivered to the project site and officially accepted by the first defendant. According to Section 41 and 42 of the Sale of Goods Act 1957, this is because the first defendant evaluated the crusher run, and it was only after the result of the second test in which the crusher run were found to be in compliance with the JKR regulations that the first defendant supplied and finally applied the crusher run in the road project. Third, the second defendant had signed the agreement and conditions of the guarantee on behalf of the first defendant. As a result, in the absence of fraud, the defendants were obligated by the guarantee's provisions. And finally, because of the defendants were unable to authenticate invoices for the supply of the crusher runs from the other vendors, the case was dismissed. The defendants had failed to prove that the plaintiff crusher runs were defective. As a result, the defendants' claims for the cost of buying crusher runs from the other vendors was unsuccessful. Here, I conclude that the defendants are entitled to file this case because after they completed the project, they found that the finished work had been damaged. Therefore, they considered that the damage was caused by poor quality material and that the quality of the material did not match or reach the set standard of the JKR. Lastly, I agree with the decision of the court which said that the defendants had failed to prove the plaintiff's crusher runs were defective. As a result, the defendants' claim for the cost of buying crusher runs from other vendors was unsuccessful. Okay, I guess that's all from my explanation of the legal case related to Gemencheh Granite Sdn Bhd versus Puncabahan Sdn Bhd and another. Thank you for listening to this video and have a nice day.